All right, very good. So the first form we're going to look at for a buyer that you need to go over with that buyer, probably they say first substantial contact. So if you meet someone at an open house, or if you meet someone in the line at the grocery store or whatever, and they start telling you about their finances, that is considered first substantial contact. Just a conversation about, yeah, I'm a realtor. Oh, I've been thinking about buying a house. Well, call me sometime. That is not first substantial contact. So it first substantial contact begins when they start sharing personal information with you that frankly, it probably makes you feel a little uncomfortable the first time. So what I do then is I say, hold it. Before we go any further, I need to explain to you about agency. Okay. Now I will say that this form has been updated, and I just saw it for the first time this morning, the new one through the Real Estate Commission. So we'll probably do a class or a recording of how you actually fill that new form out, but there's nothing wrong with this one until you get some experience and see the next the new form that they've come out with. So working with real estate agent describes agency. And I know you guys learned about agency in your class. Agency basically means, who do I work for and who do I owe my diligence and my professionalism and my knowledge and my loyalty to, right? So if I'm working with a seller, I'm maybe considered a seller's agent, and that's usually a listing agent. Okay. And in bold print, it says, until you sign the listing agreement, you should avoid telling the listing agent anything you would not want a buyer to know. So if you're going on a listing appointment and there are 3 or 4 agents that they're interviewing, they haven't signed anything. So anything they tell you, you can use against them, you might say. Like if they tell you, 200 is my bottom line, but I want to list it at 250 or whatever the case might be. But then they go hire somebody else. That gives you that information that you are allowed to share with a potential other buyer. So that's why this form is important to review early on when you make first substantial contact, so they understand they better not open their mouth, because whatever they say can and will be used against them. Okay. So this is basically, if you're a listing agent and you're only a seller's agent, your loyalty is to that seller, and you would not disclose anything about them personally to any buyer or any other agent. You have to disclose any material fact about the property itself. So if they tell you that the dishwasher doesn't work, that's something even though they may not want to tell anybody, you have to tell, because that's your duty as an agent with a license, means you have to disclose material fact. And the fact that something does not work in the house is a material fact. Then we have a dual agent. So since the listing, or even with a buyer agency agreement, is with the firm, that if they go under contract with a buyer or a seller, depending on what they are, with someone else that works at Keller Williams, that puts us in a dual agent situation, because the agency relationship is with the firm. So in that case, if you are the agent for both the buyer and the seller, that puts you in dual agency. But we also practice what we call designated agency. Designated agency means that even though the buyer's agent and the seller's agent work for the same firm, they're basically acting like you all work at different firms. So I recommend that you practice designated agency instead of dual agency for you personally, because you being the dual agent in both sides of the transaction opens up for a lot of lawsuits and some discomfort. And it puts you in a position that you can't really give them good information. You cannot suggest a price. You cannot suggest any strategy with regard to preparing an offer or accepting an offer or countering with an offer if you are the dual agent involved in both sides. This next section talks about buyers. So you have a few choices. You could act as a buyer's agent, and that would mean you have a written agreement with that buyer that you are going to act on their behalf and look at their best interests. I would say probably 50% of the time, agents may show a house to a buyer before they have a written agreement. And you can have unwritten agreements with people, but once you go to create an offer to purchase for that buyer, then your buyer agency agreement needs to be in writing. So there's also this thing called money, right? So we do this for a living. We expect to be paid. And in many cases, your pay is going to come from the seller because they have agreed on their listing agreement that they would pay a buyer's agent a certain amount of money if they brought a buyer. So through the listing agreement, the listing agency creates with that seller that says, I'm going to make X amount as your listing agent, and then we're going to pay a buyer's agent this amount. It used to be that it was always the same, right? If the total commission was 5%, the listing firm got 2.5%, the selling firm got 2.5%. But that's not a rule. So I see a lot now where listing agents will keep 3% and maybe charge a 5.5% commission, and the listing agent gets 3% and the buyer's agent just still gets 2.5%. So there's nothing wrong with that. That's totally legal as long as that's what the seller agreed to in the listing agreement. And you wouldn't have any privy to that information because you would be the buyer's agent. So while we used to say, why not use a buyer's agent because they're free, that we're not really free, because the buyer agency agreement says, I may get money from the seller, but if I don't, you have to pay me. And we're going to look at that document after we finish this one. So this also talks about designated dual agency around dual agent. It's the same principle. But then there's this other little interesting category, and that's a seller's agent working with a buyer. And if you are going to help a buyer write an offer and present an offer on a listing that you have, this is probably your safest bet with regard to not getting yourself into trouble. But you cannot share anything about that seller with that buyer because you are a seller's agent. You can help them find a mortgage company. You can help them find a closing attorney. You can do all of those things because those things in the end, they help the seller because you're helping the buyer get the financing and the things in place that they need to be able to buy. But as far as making suggestion on how much should I offer and those kinds of things, you're not in a position to do that as a seller's agent working with the buyer. They can tell you what they want to offer and you can write it on a piece of paper and they sign it. That's basically it. So at the bottom of the different descriptions, there's a place for the agent to fill out. So you'd enter the agent name, your license number, the firm's name, and then the date. The only time you will check this box and initial is when you are acting as a seller's agent working with the buyer. Okay. And if you are a seller's agent working with a buyer, then down here, this page 4 is where the buyer would sign that says you went over this with them. They would print their name, sign it, date it. When you enter your information on this page, it automatically fills in on page 4 under the firm name, agent name, license number, unless you print this off and you handwrite it. And then they will check this, you will check this box and have them initial here saying, yes, I know that he or she is a listing agent. They're just helping me with the paperwork. Okay. And believe it or not, people do that. They are fine with that. Because in this world, you know, they have access to internet, right? So they can learn all they think they need to know on the internet and be able to represent themselves.
Jody, I have a quick question. Is this something that can be completed through DocSign or DocuSign?
Sure. And it's in there.
Okay.
There's a form for a seller and a form for a buyer. They look exactly the same, but the difference is when you enter the overall information about that opportunity, and you put in that you're working with a buyer, you would need to select the buyer form so that it would automatically fill their names in the right place. Okay. Other questions about this form? This is a good one to role play. I think a lot of people don't go over it because they're nervous or they don't know what the right thing is to say. And so I would strongly recommend you practicing on with each other even and getting comfortable with this, because this really sets the stage for how you're going to proceed. And this is the one thing people get sued over the most, probably, is, well, I didn't know they weren't working for me. You know, they called me, they helped me write the offer. I didn't know they weren't working for me. And they wouldn't know unless you went over this with them. All right. Okay. So the next form we're going to look at then is a buyer agency agreement. So a buyer agency agreement is an agreement between the buyer and the firm, and you are the representative of the firm that hires you to find real estate for this potential buyer. So there are other things that go along with this. One is it tells you and them how you're going to get paid, but it also outlines what your responsibilities are and how long the agreement is for. And it's a requirement before that you have this signed before you have help a buyer write an offer to purchase. So it's got to be in writing before you make an offer on something. So the first thing this says is what date is this agreement going to be entered into? So you'd fill in the date here. And again, this form can be done online as well through DocuSign or any other transaction management system. And then you would list the buyer's names in the second. space, and then the firm's name in this third space. So this says that you are the exclusive agent for this buyer, which means they should not enter into one of these agreements with another agent, because then they're obligating themselves to pay both of you. So the first thing you're going to want to ask is, have you entered into a buyer agency agreement with another agent? And if they say, well, yeah, but we don't like them, we don't want to work with them anymore. Well, have you and the agent agreed to cancel the agreement? Well, no, I just told them I didn't want to work with them anymore. That's not good enough. So you cannot enter into an agreement, or you should not, because that's against the code of ethics, into an agreement with someone that's already in an agreement with someone else. It's kind of like cheating on your wife or your husband. Just kidding. Down here, it says in bold print that the buyer represents that as of the date of this agreement, the buyer is not a party to a buyer representation agreement with any other real estate firm, and that they have received a copy of the Working with Real Estate Agents brochure, and they have reviewed it with the firm or with you. So the first, number one, is type of property. So they're looking for residential, commercial, or something other than that. And then A is the general location. So general location could be Brunswick, New Hanover, or Pender County. It could be Wilmington. It could be southeastern North Carolina. Any of those descriptions will work fine. Then number two is the effect of the agreement. So how, this says that by employing the firm as the buyer's exclusive agent, the buyer agrees to conduct all negotiations for such property through the firm. So that means they don't need to be out there negotiating on their own terms or on their own. They need to be working through you. Number three is the term of the agreement. So how long does this thing last? So we would start it today. Or you may start it when, if they've entered into another agreement with another another agent as a buyer, and it expires on April 30th, then this agreement might start on May the 1st. And as long as they're the ones that reached out to you and you didn't reach out to them to get them to work with you, you're fine. And then the next question is, what is their intention? So the first box that you could check would be for buyers who intend to purchase a single property. So they're moving here from Alaska and they got to buy a new house to live in. So that's, in most cases, that's going to be your choice. And then how long does it last? So I see anywhere from 3 to 6 months to a year. If you're working on a team, they probably have a policy. If you're by yourself, you'd want to consider probably the longer the better for you to protect you, especially in this market. Lord knows how long it takes to find a property for a buyer these days. But 6 months is probably a comfortable number in there. And then the second box would be for buyers who may purchase more than one property. So maybe it's an investor that's going to buy 5 or 6 rental properties. So this is kind of a blanket buyer agency agreement that says it doesn't expire when you buy that first property. It's in place for the amount of time that I put in here. Number 4 talks about compensation. How am I going to get paid? In some markets, agents require a non-refundable retainer fee to be paid by the buyer to them before they put them in the car. I know Chapel Hill is that way. I referred a young buyer to an agent in Chapel Hill, and she called me and she's like, man, she wanted me to give her $500 before she'd even talked to me. I said, okay, well, let's not do that. Let's find another agent for you. So I know that in some parts of the state, it's becoming common procedure that the buyer give the agent a non-refundable retainer fee to just get started, to have them work with you. And then you would, if you decided that's something you wanted to do, then you would also check the box as to whether it would be credited towards any compensation due the firm under the agreement. So B, buyer agrees that firm's fee for services hereunder shall be in the amount of. So I see a lot of mistakes made in this place, because a lot of agents say, oh, per MLS. No, that's not good enough. You need a number, and you may or may not get it from the seller through MLS. Maybe it's a for sale by owner and you have to negotiate that commission paid by the seller. And if they don't agree to pay it, then the buyer has to pay it. So here I see 2.5%, I see 3%, I see 3.5%. If they're looking for land, I might even see it 4%. But that's the amount of money you expect that buyer to pay you for your services. And yes, a good portion or perhaps all of that may come from the seller, but it doesn't have to. So here's the tricky part. If you put in there 2.5%, you're probably covered if they buy something that's through the MLS. If you put 3% in there and the MLS shows that a buyer agent will only receive 2.5%, then there's a 0.5% difference that, according to the way this document is written, that buyer would have to give you 0.5% towards your fee at closing. So just make sure whatever you put in there is agreeable and understood by both parties. So this says that the firm shall seek from the fee from a cooperating listing firm. So that would be the seller paying the fee. If the buyer purchases a property where the compensation offered by the listing firm and or seller is less than the fee, which is what I just talked about, the buyer and firm agree that buyer will pay the difference. And then number 3 says, if additional compensation, incentive, bonus, rebate, and or other valuable consideration is offered through the MLS or otherwise, a buyer will permit the firm to receive it in addition to the fee. So maybe the seller says, hey, I'll pay a buyer's agent $1,000 bonus if they bring me a buyer by May the 1st. This gives permission for you to accept that $1,000. There is a form for that. You can also use that to confirm the disclosure of any of the additional compensation. And the compensation shall be deemed earned under any of the following circumstances. So number 1 says, if during the term of the agreement, the buyer, any assignee of buyer, or any personal legal entity acting on behalf of the buyer directly or indirectly enters into an agreement to purchase, blah, 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 blah. So they buy something. Number 2 says, and I'm going to just paraphrase this. So let's say your buyer agency agreement is good through May the 31st. And on May the 25th, you show them a property and they really, really like it. If you have 30 days written in this blank, that says that if they decide to buy that property within 30 days of the expiration, they agree to honor this agreement and you would still receive that commission. However, if they've signed a new buyer agency agreement with another agent, you're out of luck. Number 3,
Jody,
yes,
is 30 days pretty standard?
30, I see 30, I see 60, I see 90. I've never seen any more than 90, but 30 to 60, I would say, is more common. And that protects you so that when this expires, they don't go directly to the seller and say, hey, I'll buy your property and we don't have to pay a commission because I'm out of my buyer agency agreement, right? Then number 3 says, if the buyer defaults under the terms of a contract, they still might have to pay the fee. So if the buyer, excuse me one second. Give me 1 minute here. My assistant's going to pick up checks and I don't think they're ready. Hey, I'm teaching, but I don't know if the checks are ready yet. So let me look and I'll text you back. All right. Okay, bye. Okay, sorry about that. Let's say the buyer goes under contract, they go through inspections, they go through their whole thing, and the day before closing, they say, oh, I changed my mind. I don't want to, I don't want to buy it. I'm not going to buy it. You could still hold them accountable to pay your fee. I don't know that we've ever done that, but I know there are some firms in town that will send them a bill. Say, okay, you don't have to buy it, but you owe me a fee because I found you what you're looking for and you waited till the day before closing to walk away. And then D says a compensation will be due and payable at distribution of proceeds. So there's no fee to be paid until closing, unless that's one of those situations where they walk away and the property doesn't get closed on, and then they owe for the money. They owe for the buyer agency fees. In the blue box, it says that the buyer understands and acknowledges that there is a potential for a conflict of interest generated by a percentage of price based fee for representing the buyer. The amount, format, or rate of real estate commission is not fixed by law, but is set by each broker individually. So when you ask me how many days I normally see that, I feel comfortable talking about that. As far as what people charge for a commission, we don't fix those costs across the market because that's antitrust law, against any antitrust law. So our firm requires a minimum 5% listing unless you get permission to do something different, which means that the buyer side would receive 2.5%. So this talks about whether we end up in a lawsuit with the buyer. And this just says if the firm is prevailing party in any legal any legal proceeding brought by firm against the buyer to recover a fee, the firm shall also be entitled to recover from the buyer any reasonable attorney fees and court costs. So to the buyer, it's like, don't make me sue you. And then F, if the buyer purchases unimproved property, the agent may assist buyer in identifying a contractor to make improvements on the property. So if the buyer purchases a vacant lot and then you help them find a builder, you can also receive a referral fee or a fee from that builder, even though you're not selling real property to that builder. Does that make sense? Okay. And then it says that the buyer understands that other prospective purchasers represented by the firm may seek property, submit offers, and contract to purchase property through the firm, including the same or similar property as buyer seeks to purchase. So this means I might be working with 3 different buyers that are looking for the same kind of house or property. And I may have all 3 of them making offers on the same property. And the buyer says they understand that. Number 6 talks about the firm's duties. So it talks about performing the terms of the agreement, seek property at a price and terms acceptable to buyer, represent in a timely manner all written offers on or counter offers to and from the buyer, and disclosing to buyer all material facts related to the property or concerning the transaction of which the firm has actual knowledge. So if you know that the dishwasher doesn't work, you have an obligation to tell that buyer that the dishwasher doesn't work. Now, I know that in some cases, you all probably talked about this in class about what is material fact and what isn't, right? Did you all talk about that in class?
Yeah.
Yes.
Yes.
Okay. So anything that has to do with the property itself or its condition is considered material fact. If a sex offender moved 3 blocks away, that is not material fact. If someone died in the property, that is not material fact. Okay? But if something doesn't work, that is material fact. Okay. And then this last little sentence says, upon closing of any sale of property that's not in the listing service. So if you help a buyer purchase a for sale by owner that was never in the multiple listing, the buyer gives you permission to put it in there so we can use it as a comp and so that you get credit for it in the listing system. Number 7 says you have permission to disclose the buyer's name and their mailing address if needed. Number 8, fair housing. Non-discrimination. The agent or firm shall conduct all brokerage activities in regard to this agreement without respect to the race, color, religion, sex, national origin, handicap, or familial status of any party or prospective party. Further, so that's the HUD rule. Further, realtors have an ethical duty to conduct such activities without respect to the sexual orientation or gender identity of any party or prospective party. So the NAR, National Association of Realtors, added sexual orientation and gender identity to their non-discrimination clause. Number 9 talks about the buyer's duties. Go over this with them. I'm not going to read everything on these forms. You guys are big boys and girls. You can do that. But the main things I want to point out, if they see a listing, if they're driving through a neighborhood and they see a sign out that's a for sale by owner, make sure they call you and give you the information and give you the opportunity to schedule that appointment for them. That's your job. Other professional advice. This is one of my favorite paragraphs in this agreement. This says, you're hiring me to be your realtor. You're not hiring me to be a tax accountant, an insurance agent, a surveyor, a termite guy, a structural engineer, a builder, or anything else. You're hiring me to be your realtor. So if we need services from one of these others, we got to pay for it. We got to hire it out and pay for it. The next 3 lines say that the buyer acknowledges receipt of, and there's a sample copy of an offer, There's a brochure about questions and answers on home inspections, and then there's a sample copy of a professional services disclosure. If you don't give them one, don't freak out. It's okay, because they're already pretty blown away with the whole process. So only check the box if you've given it to them, but it's not a requirement for you to share those things with them at this point. What I usually tell a buyer is, I'm happy to share one of these and let you review them, but please know that when we get to that point and we're going to go forward with an offer, I'm going to describe it and share it with you, and we're going to go through it in a lot of detail. So don't feel like you have to have it before we go write an offer, because we're going to go through that in a good detail. Number 11, it talks about a home warranty. So it used to be that warranty companies offered realtors a little kickback or a commission or a fee, referral fee, if you sold one of their warranties to their client. And I only know of one company right now that still does that, but you have the option of passing on the savings to the buyer. And that's usually what I do. So if you are going to collect a fee, then it requires you to disclose what that fee is in that blank. If you're not, and you're going to pass any savings on to a seller or a buyer, excuse me, you would just put 0 in there. 12 talks about confidentiality of offers. If they make an offer on something, you can't tell anybody about it except for that listing agent and that seller. If you have 2 buyers that are making offers on the same property, you can't tell the other one about what the first offer is. It's confidential information. And then number 13 allows you to list any additional provisions. 14 talks about dual agency in more detail. And talks about buyer's role if you do become a dual agent, or if the firm becomes a dual agent. And then here is where they would initial what they will allow. Now, if they say they want exclusive representation at all times during the agreement, that means that you can't show them any property that any Keller Williams agent has listed. So just make sure they understand that. So that's why the designated agent option is a good choice, because it allows you to show them other Keller Williams properties, but not put the firm in a full dual agent situation. Okay. F talks about dual agency compensation. So if that buyer decides to purchase a property that is listed with another Keller Williams agent, how much will the firm expect to be paid? So it might be 5%, it might be 6%. Pick a number. And then number 15 says if we end up in a dispute and we can't settle it through negotiation, then we agree to go to mediation. 16 says that this is our entire agreement, and that any changes or termination shall be in writing. There's another form for that. So we don't have any side deals going under the table with that buyer. And then in blue print here in this box, it says buyer should consult with firm before visiting any resale or new homes or contacting any other real estate firm representing sellers, to avoid the possibility of confusion over the brokerage relationship and misunderstandings about liability for compensation. So if there's an open house held in a neighborhood where they have been looking in, and maybe you're out of town, okay? Hey, I'd really like to go to that open house. Great. I give my buyers a stack of my cards and I say, go for it. And when they go to that open house, the first thing they do is say, we're working with an agent and here is her card. She's out of town, but she told us we could come and just take a quick look. Period. Okay? Same with model homes. So when you go to a model home, a new construction, that agent in there is working for that builder or that developer. So don't let it fool you. Give them a handful of your cards if you know they're going to be shopping like that, and they can share with that agent your name and your information. So there's no dispute. Okay. Number 17 talks about surveillance. So it's legal for a seller to have a video camera on while they're showing the house. It is not legal for them to have audio turned on. However, we know that sometimes it happens. Someone asked me about a Ring doorbell once, because it does record audio. So just be aware. So all this is saying is be aware that people may be watching and they also may be listening. So watch what you say and do when you're in someone else's home. Have respect. I had a seller call me about one of our agents about a month ago. He's a security guy. That's what he does for a living. Imagine that. And he's a retired cop. And he said, your agent grabbed my television that was mounted on the wall and shook it. And if there's any damage to that, I'm going to sue them. They'll owe me a new TV. And I'm like, okay. So I called the agent and I'm like, what were you thinking? He goes, I know the cameras were on. I was just seeing if the TV could be moved so you could see it from another part of the room if you put the couch over there or something. So anyway, bottom line is people are watching. So just be very careful of what you're doing and what your buyers are doing. And then the next section is about photographs and video. So this just says that the pictures of the house are usually posted online. And if you end up buying that house, it's very difficult, if possible, even possible, to pull those pictures down. So this is just sharing that. Yeah, there's going to be pictures out on the internet of this house for a couple years probably. So that's just the way it is. So in red, it's all about wire fraud. So wire fraud is the thing right now. People, I don't know why people just can't earn a living doing something constructive, but there are people that prey on others and try to get access to other people's money through wire fraud. So what I'm telling you is, if a buyer is going to purchase a property, you let them get wiring instructions directly from that closing attorney, and you leave it between them. You stay out of it. If they go, oh, I didn't get wiring instructions, call the attorney, say, please send the wiring instructions directly to that buyer, and you don't get a copy. You stay out of it. And then this last page is where everyone would sign it. So you would have contact information here for buyer number 1, their mailing address, and they would print once you entered them as buyer number 1, it would print their name here, and this is where they would sign and date. Then there's for buyer number 2, same thing. If your buyer is an entity buyer, so let's say they're buying a property in the name of their LLC. So it's Jody LLC is going to be the owner. Then I wouldn't have their names up here. I would have it down here, and my entity buyer would be Jody LLC by Jody and the date. And then here I would have Jody's name spelled out and their title with the organization. So if I'm the president of the LLC, if I'm a managing member of the LLC, whatever my title is with that entity is what you would list here under title. And then you would put their contact information. And then at the bottom is the firm's information. So it would have Keller Williams here, the firm license number here. If you all have something to write with, I can give you our firm license number. You're going to need it. It's C as in cat, so it's capital C 26008. 26008. That's our firm license. And then our office address would go here, your name down here, and then you would sign here, your license number, and then your phone number, a fax number, and your email. That's it. Only 6 pages. Questions? No questions? Have I lost you? Are you all there? I know it's boring. I'm sorry.
No questions.
No,
no.
I'm here. I don't have any questions.
I can't wait till we can do this in person again. It's
Right.
hard to do forms training on Zoom.
It's just a lot to have to fill out, really.
It is. And to explain, right? So
Mm-hmm.
so there's a little saying that a lot of us in the business have, and that is that realtors don't read. And so we all may be guilty of that a time or two. But what I would tell you is you need to read these documents and really internalize them and understand them before you can describe them and explain them to a potential buyer.
Jody,
Yes.
when we're going to be sending these forms through DocuSign, I assume.
Uh-huh.
So is Command going to auto-populate a lot of this, or is a lot of this we're going to be filling out ourselves?
So you fill it out in DocuSign as to who's buyer number 1, buyer number 2, and that stuff. And it auto-populates a lot of that in the document. But there are still some things you have to come up with on your own.
Okay.
Commissions, amounts, number of days, dates, that kind of stuff. But if you say, this is my buyer number 1 and this is my buyer number 2, it automatically throws their names and their information in.
All right. Excellent.
Okay?
Yep.
All right. So our next document is going to be an offer to purchase. So once you've gone over the working with real estate agents brochure and you've entered into a buyer agency agreement, the next potential document you're going to have to fill out is an offer, right? So you've been shopping, you've been looking for a house. Now you found one. Now what do I do? So you asked me about the auto populate. If you enter those buyers' names and you create an offer, it's automatically going to put their names in here as the buyer. You would probably have to put in the seller's name. And I'm going to show you why. So I'm going to go to Flex. Have any of you been into Flex, to the MLS system yet? Probably not if you just started.
Yeah, I've been into
No,
it.
I haven't yet, but
So Wednesday morning, 9 to 11 is MLS Basics with me. But I'm just going to show you, this is what the system looks like. And if I go to any random listing, just for the heck of it, and I look down here at the seller's name, oh, sure, the very one I look at is done right. If I look at the seller's name, This is an LLC, this particular house. Find another one. A lot of times what will happen is the owner's name will just be their last name. So you'll need to get more information about their full names. Okay, here's one. So see here, it says owner Daniels. Well, it might be Randy Daniels and Mary Daniels. So you would have to split those out so that they would appear in the document correctly. Does that make sense? And it's all about how a person enters the listing into the MLS. If they don't do it right, that's what you're stuck with.
So
Okay.
what
Yeah,
you're
go
saying
ahead.
is it might auto-populate it, but a good chance it's going to auto-populate it incorrectly.
Yes,
So to double check that. Okay.
that is correct. It might just say Daniels. So then you would have to go in and manually change it to Daniel, Mark Daniels and Mary Daniels or whatever their names are. Okay. Then you have the buyers. Once you create the buyers in the system, that would automatically populate them. You would enter the address. And again, if you filled this in, it would automatically populate there as well. Right here in this blue box, it says, if the property will include a manufactured or mobile home, buyer and seller should consider including the manufactured home provision in the additional provisions addendum. What I will tell you is, if you have a buyer that's going to make an offer on a property that has a manufactured home on it, just call me. We'll go through it together because it can be very complicated. It can be more complicated than buying a condo or a townhome or anything else, because so much depends on whether the manufactured home is now become real property, if it's permanently attached to the land, and if they did all the right things through the tax office and the DMV to make sure that was done properly. Then the next section is the legal description. So where do I find that? I can find this in one of two places. If I go to my listing, let's say this is the property that they're going to make the offer on. I have my PID or tax identifier number right here. So if I go to my transactions, back to my document, it says PIN or PID or other identification number of the property. That number would go into this blank. Everyone follow me here? Right here, PID or tax identifier. That number goes into this blank, the PIN, PID, or other identification number. All right. Then it asks for other description. So if I go back to the listing and I go down here, my legal description is lot 3, phase 1, the lakes at Johnson Farms. So what I normally do is just this. I copy it, select it, copy, and then go over here, put my cursor in here and paste it. And there it is. Okay. The plat book and slide or the page number, those are where the maps are recorded at the courthouse. In New Hanover County, you don't see that very often, or we don't use that very often. But Pender and Brunswick, usually that plat book and page number is part of the legal description. And then the other most important part is the deed book and page number. So the deed book and page number is when that person bought that property or became the owner of that property, the deed that they received the property through is recorded at the courthouse. And they want to know what deed book and what page number that deed is recorded in. So if I go back to my listing, I have deed book and deed page. So it's 5329, 2293. So right here would be 5329. And I already forgot my number. 2293. And page is 2290, oops, 93. Okay. So that's all you really need right here. Oh, and your tax ID. Let me go ahead and fill that in so you see that. So I got my tax number. I'm going to go right here. I'll select it. Oops. And there's my tax ID. Questions on that? You can also find this from the tax record, but if the property is listed in the MLS, it will have it in there already. Okay, then the next section is how much are you going to offer for the property? What's the purchase price? So if I'm working on an offer for this one, the purchase, what they're asking is $289,900. So let's say, okay, I'll offer them what they're asking, $289,900. Now, due diligence fee. So let's talk about a fee versus a deposit. A fee is an amount that you pay that you're not ever going to get back. It's an expense, and a due diligence fee or expense is what you're paying directly to the seller to take that property off the market while you do your inspections, your appraisal, you get your loan in place, you let mom see it, whatever you need to do during that period of time to make you confident that that's the property you want to buy. So the fee that you're paying is a non-refundable fee paid directly to the seller. The contract says it's delivered to the seller by the effective date. So the effective date is when the buyer and the seller both sign the offer, right? So you come to an agreement, the seller signs it. This agreement says on that day is when they should receive the due diligence fee. I'm seeing a lot more where people are electronically transferring the money. So maybe through PayPal or Venmo or Cash App, any of those. And that's totally fine. You just need a paper trail to show that it came out of their account and went to the seller's account so you can share that with the lender. So let's say we're going to offer them $1,000 in due diligence money. When you get that $1,000 check from the buyer, hold the check in front of them and look them square in the eye and say, there is a 99% chance you will never get this money back. Are you comfortable with that? I am seeing it with the way our market is. I'm seeing people giving $10,000, $15,000, $20,000 in due diligence fee. And then they come back and go, well, there was moisture in the crawl space, or there was this, or there was that. So I should get that money back. No, not necessarily. Now, if the seller put on the property disclosure that everything worked well and there was nothing wrong with it, and then you can prove that they knew there were problems and did not disclose, that's another issue. But that buyer would still need to go to court to get that money back if they felt they were misled, that it was not disclosed to them that there were those problems. Okay, then we have earnest money. So the due diligence fee is payable at the time the offer is signed, and it's good for a period of time, let's say 3 weeks. During that 3 weeks, you're going to do property inspection, termite inspection, survey, appraisal, all of the things that get your insurance put in place. The next page goes through in a lot of detail. Let's say our due diligence date is May the 15th, just as a round number, a round date. After May the 15th, then whatever money I put up for earnest money is now on the chopping block. So if I walk away prior to May 15th, I would lose my my due diligence fee of $1,000. Let's just say that we're going to give 5,000 in earnest money. So if I walk away prior to 5 p.m. on May 15th, I lose my $1,000. I get my $5,000 back. Okay. If I walk away after May 15th, but prior to closing, I lose them both. So earnest money deposit is, at Keller Williams, we do not hold earnest money if you're on the listing side of things. So what we recommend is that it can be held by the closing attorney. So this next two questions is, how is it going to be paid? Please don't accept cash. You need a paper trail. So a personal check, a bank check, even a wire transfer or electronic transfer is fine. So check the appropriate box and then check this box as to when the amount of money will be paid. The first choice is with this offer, and that doesn't happen very often. So just be straight up and say, yeah, within 5 days, I'm going to get you my earnest money. That 5 days is only good for the earnest money, though, not for due diligence. The due diligence is due the day on the effective date. The next blank is for any additional earnest money deposit. So maybe after 30 days, I'm going to give 5,000 now, and then maybe I own a house that has to sell, and maybe that's going to go it's under contract and it's going to close on May 10th. So maybe after my house closes, I'm going to give another 5,000 on March the 10th. May the 10th. Because that's the day that my other house closes. So I'm going to put up yet another $5,000, and hopefully this seller will consider my offer. The next one is about a loan assumption. So we don't hardly ever have those, so I'm not going to spend any time on that. I do believe, however, with as low as interest rates are right now, that 3 to 5 years from now, we'll see more loan assumptions come back because the rates are so good. And then the next one is about seller financing. So if the seller is willing to act as the bank, the buyer says, hey, I'll give you $10,000 down and make monthly payments for the first 3 years, and then I'll pay it off. I'll refinance it. That would be the amount of the loan that they would be holding. Again, those are real specific terms. So just come see me if you have someone that's offering to do that. And then if you're using a new construction addendum, so maybe they're buying a new house, it's finished, but you have to use the addendum, then they may be putting out a building deposit. So that would go in this line. So the system automatically takes the 289.9 you put up here, and it deducts all the different amounts. So the balance due at closing in this case is 278.9. So at the bottom of this page, it says, should buyer fail to deliver either the due diligence fee or any initial earnest money deposit by their due dates, or should any check or other funds paid by buyer be dishonored for any reason by the institution upon which, so if the check bounces, the buyer shall have 1 banking day after written notice to deliver cash, official bank check, wire transfer, or electronic transfer to the payee. So we would see this a lot. The buyer goes under contract, and then they have buyer's remorse and they never pay the due diligence fee. So I have agents that call and go, what do I do? They never brought me the money, or they won't pay the fee. This is what will have to happen. The seller will have to provide them written notice that they owe the money. If it happens today, they would have by the end of the day tomorrow to provide cash, official bank check, wire transfer, or electronic transfer. In the event the buyer does not timely deliver the required funds, the seller shall have the right to terminate this contract upon written notice to buyer. So if they didn't pay it, the seller can terminate. They still owe the money though. So the seller could take them to court because they did go under contract.
Hey, Jody, if they don't pay, is that something I would take to the listing realtor and be like, hey, my clients are not coming up with the money?
Sure,
Okay.
sure. And they'll probably tell you, well, my seller could sue, and you say, yes, I've
Yeah.
told them that, and they still don't want to pay. You know, if it's $100 or $500, it's very unlikely the seller's going to do anything. But what I normally tell buyers agents is, you know, when you get them to sign this offer, have them hand you a check. Then if you have a check that bounces, that's a lot easier to recover in the court than just taking them to court because they never paid it to begin with, right? A bad check is a lot easier to get. So this next section talks about earnest money. So this is money that's held in escrow, most of the time by the closing attorney, and it is credited to the buyer along with the due diligence. It is credited to the buyer at closing. So if we look back and we say, oh, they paid $1,000 in due diligence and a total of $10,000 in earnest money, then they would get a credit of $11,000 that they've already paid to the transaction. So again, if the buyer walked away prior to the due diligence date, they would receive the earnest money deposit back. If they walked away after the due diligence date, they would lose both. That's what this is a big long paragraph that says that's what happens. F is where you put the closing attorney name or whoever is holding that earnest money, the escrow. And then in blue box, it says, in the event of a dispute between the seller and the buyer over disposition of the earnest money deposit held in escrow, a licensed real estate broker and an attorney is required by state law, if not a broker, hereby agrees to retain the earnest money deposit in the escrow account. So what that means is I can't give it away. I know who should get it, but if y'all are fighting over who should get it, I'm not the court, and I'll hold it for a period of time. And if no resolution has been agreed upon, then I have to turn it over to the appropriate clerk of courts in accordance with the provision, and there's a state provision. And then maybe nobody's going to get it. I've only had a dispute one time, and it was over $500, and they finally agreed that they would just split it. So that's what happened. And then this bold print down here just says if the escrow agent puts it in an interest-bearing account, it gives them permission to gain interest on that money. I don't know of any attorneys that do that anymore. It's so hard to keep up with. G talks about the effective date. So the effective date is the date that the last person initials or signs that creates a binding agreement. So if there's a place that you had to change and you scratch through it and put the correct number in there or whatever, everyone has to initial that before it becomes a binding contract. And whatever date that happens becomes the effective date. H talks about due diligence. I talks about the fee that's paid. Again, this says that it shall be non-refundable except in the event of material breach of this contract by seller or if the contract is terminated under 8N or as otherwise provided in any addendum hereto. So again, it is 99% of the time it is non-refundable. Here's where you'd enter the due diligence date. Settlement talks about closing and what that date is. M talks about what closing actually means. So the closing is when the deed gets recorded and the attorney disperses funds. So when a buyer goes to the closing table and they sign their stack of documents like this from the lender, that doesn't mean they get keys right away, because what has to happen is the closing attorney will update the title information. So they'll go and make sure that the that the seller didn't go out and take out a loan on the property and pull out all their cash equity out of it prior to closing. And then they have certain documents they have to send to the buyer's lender to get them to approve it. So it's usually forms that they have signed at the closing table. And then they can record the deed. So the deed gets recorded, and then the money can be dispersed. So that means that any existing mortgages on the property get paid off, the seller gets their money, we get our money, everybody gets their money. And at that point, the keys can be delivered. So the reason I'm saying this is if your buyer is closing at 3 o'clock on a Friday and they have to move in that weekend, there's a good chance they're not going to get keys until Monday. So on a Friday, you make sure your closing is scheduled in the morning if they've got to get keys by afternoon to get moved in. N talks about special assessments. So an assessment is a fee that either a government authority or an HOA charges every homeowner in that, on that street or in that neighborhood or whatever. And if it is a proposed special assessment, that means it hasn't been approved yet. So there's talk that the homeowners association might assess every homeowner a couple $1,000s to clean up the yards after the hurricane. Until that board votes on it, it is considered proposed. Once the board votes on it, then it becomes confirmed. A confirmed assessment has to be paid by the seller at closing. A proposed assessment is usually paid by the buyer once it becomes a confirmed assessment. So what I say is, if you don't have an actual bill that you can pay to settle it, then it is a proposed assessment, not a confirmed assessment. And the reason that's important is when I go to make this offer, if there's a proposal out there for every homeowner to have to pay a $10,000 tap fee for sewer installation, then I'm as a buyer, I'm going to take that into consideration when I go to offer them a purchase price. And I have to be financially prepared to pay that once the assessment is confirmed. Okay, this section talks about fixtures. So anything that's permanently attached to the property is considered a fixture and will stay at closing. So curtain rods, light fixtures, ceiling fans, mirrors in the bathroom, TV mounts on the wall where the TV's been mounted on a wall. Those are all considered fixtures and they will have to stay. And here's a list of what they are. So I would strongly recommend you look through this list. And if you know that any of these things exist in the house, you would want to look at the MLS sheet and see if there are any exclusions. So it would have them listed on one of these sections. So there are no exclusions in this particular case, but they would have to be listed on the offer to purchase. There's a place down here that you would list whatever they are. There's also a place you would list items that are leased or not owned. And the most common here are a gas tank. That's probably the most common. Maybe the receiver to a satellite dish or a satellite system. So those are leased. The only way they'll stay is if the buyer re-enters into an agreement with that service provider to keep the property, to keep that on the property. So the most common, again, like I said, is a fuel tank. E is other items that do not convey. Well, if I'm taking a listing and the owner says, well, we're not leaving grandma's light fixture in the dining room, that has to go with us. So then it would be listed as an exclusion. It doesn't mean that you can't take a fixture with you when you sell. It just means you have to disclose it. So what I normally tell a seller is, well, you know what? Before we list the property, I want you taking grandma's light fixture down and put something else up there that looks decent so that it doesn't become a dispute. Because as soon as the first person that walks in there and says, oh, I love that light, it's the prettiest light in the whole wide world, and that's the only reason I want this house, and they go, we ain't leaving grandma's light fixture, then you got a dispute, right? So take it down, put it out, pack it up, put it away, and then it's a non-issue. The common things that I see disputes over right now are the Ring doorbells, because they're part of a security system, and this says that security systems stay. So just make sure that you review this list with the buyer. So if there are any items that are in the house like this, you are clear as to what stays and what goes. Then number 3 talks about personal property. So personal property that's common are washer, dryer, refrigerator, maybe curtains. Blinds are considered a fixture because they're permanently attached to the window. A curtain rod is a fixture. The curtain itself is not. This same section, this whole page and up to here is also in the listing agreement. So those things should match. And it's up to the listing agent to make sure that when an offer comes in, if there is an exclusion, that it has been properly identified on this page. Number 4 talks about buyer's due diligence process. So these are the things that they need to be doing. Make sure their loan is in place. This offer is not contingent on obtaining a loan. So they need to get that loan in place prior to the due diligence date. Then they would also do their property investigation. So inspections, reviewing documents, making sure they can get affordable insurance policy, getting appraisals done, surveys if they decide to, any zoning or governmental regulation. If they plan to build a garage in the backyard, they want to make sure that's allowed before they move forward. Whether or not they're in a flood zone and what the cost of that insurance would be. Utilities and access, and then who owns the roads, right? So if it's on a public street, I know I'll never have to pay for that to be updated or fixed if there's a hole in it. If it's a private road, that means it's going to fall into the homeowners association responsibilities that I'm a member of. Or if there's a road maintenance agreement, that means that everybody that lives on that street has to pay their share to get that road fixed. And then the fuel tank.
Jody, you said at the beginning of that the offer is not contingent on the buyer's ability to obtain financing. What if the offer is contingent on the buyer's ability to obtain financing?
So you would have to get an attorney to draft an addendum
Okay.
that would state that.
Okay.
What the common thing to do is now is allow for enough time during the due diligence period to accomplish that. And then if it's not approved, then you could get your earnest money back. You would lose the due diligence, but you would get your earnest money back.
Okay.
Okay. So again, I mentioned that also the sale of an or lease of an existing property is also not part of the condition of the contract. So we'll see a page here, but that's something you would also need to take into consideration when you set your due diligence period. If they own a house and it's under contract and it's scheduled to close on May the 30th, don't make your due diligence date prior to May the 30th. Because then you put them at risk of losing their earnest money deposit if the sale on their home fell through. Repair improvement negotiations. So you do your inspections, comes back that there's a toilet leaking under the house and it's caused some of the subfloor to rot. So that's something that the buyer says they want fixed. So you would prepare a repair request and in detail describe to them how you want that fixed. So in bold print, it says the property is being sold in its current condition. So that means it is an as-is sale no matter what. But if the buyer wants to ask the seller to fix something, then they do it on a repair request and turn it in. It doesn't mean that the seller has to do it, but it gives them the option of fixing it instead of losing that buyer out and having to start all over. E talks about buyer obligation to repair damage. So if they're in there doing inspections and the inspector sticks his screwdriver through some soft wood and the whole piece of wood crumbles and falls apart, then they're required to fix that because they created damage. So the buyer is obligated to repair it through the people they hired to do that inspection. The buyer indemnifies and holds the seller harmless from any loss, damage, or claims. So if the home inspector's walking through the attic doing their inspection and they fall through the ceiling, I've had that happen before. That means that the buyer cannot sue the seller if they fell through the ceiling, but they would have to fix that. And then G talks about their right to terminate. So they can terminate for any reason or no reason. If they just wake up on the wrong side of the bed and say, you know what, this place just is not for me, or they find something they like better, they can terminate. They would lose their due diligence fee. They would get their earnest money back if it was done prior to the due diligence date. And they can go on their merry way. Closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing. So number 5 talks about whether or not they're getting a loan. So if they're getting a loan, you would check the does box. You would check the box as to what kind of loan they were getting. And excuse me 1 second, I'm sorry. Also make sure you fill out whether it's a fixed rate or an adjustable, the amount of the loan. So in here, instead of writing a dollar amount, if they're planning to put 5% down, and you may go back and forth with price 2 or 3 times till you get to the number that everyone agrees to, you could put 95% LTV. LTV stands for loan to value. So you don't have to go and change that every time the price changes in a counter offer. And then how long the loan is for, if it's a 15-year loan, a 20-year loan, or a 30-year loan. And an estimated initial interest rate. So this does not have to be exact. Okay, if you put in 3% and the contract gets approved and they call the lender to lock in and they say, well, today the interest rate is 3 1/8. Fine, this is just an estimated amount. This first blue box says the buyer's obligation under this contract are not conditioned upon obtaining or closing any loan. So it is not contingent on them getting financing. If this says if they do not intend to get a loan, the seller is advised prior to signing the offer to obtain documentation from the buyer, which demonstrates that the buyer will be able to close on the property without the necessity of obtaining a new loan. So we call that proof of funds. So if you're going to pay cash for this $300,000 house, I want to see a statement from your bank or your investment company or something. You can hide the account number, hide any of that personal information, but I want to see something from a financial institution showing that you have that kind of cash. On this page, we say whether or not a person has a house to sell. So if they do, you would check that box. If they do not, they would check that box. If they do have a house to sell, you would enter the property address here. And then you have 2 choices. If it's under contract, you check this box. If it's not, you check this box. And then say, and by the way, it'll be listed. I'm going to list it by tomorrow or whatever. I will check that first box. It will be listed with an actively marketed by a licensed real estate broker, or is the buyer attempting to sell or lease the buyer's property without the assistance of is it a FSBO? So check one of those 3 boxes. That means a lot to a seller, right? Am I even going to consider this offer knowing that this person has a house to sell and they haven't even put it on the market? And who are they putting it on the market with? Again, this contract is not conditioned upon the sale or lease of the closing of the buyer's other property. This is strictly for information to the seller. Performance of buyer's financial obligation to the best of the buyer's knowledge. There are no other circumstances or conditions existing as of the date of this offer that would prohibit the buyer from performing their financial obligations. So they haven't co-signed on a car for their kid. They haven't done anything to overextend themselves financially to be able to afford to buy this property. Then it talks about the Residential Property and Owners Association disclosure statement. So normally that's something that's filled out by the seller at the time of the listing is taken, and it's uploaded into the MLS. So if I go to the MLS and I'm in this listing, I'm going to go over here under this More button. And the first thing on the list is documents. If I go to that, I have my residential property disclosure and my mineral, oil, and gas rights disclosure. So I can open them here, save them, and print them or send them to the buyer to review. If they haven't received a copy or it's not in there and maybe the house just hit the market and the listing agent hasn't even had time to upload it yet, which happens, then you would check that they have not received a signed copy. And then there are some situations where it may be exempt from providing that disclosure. And some of the most common are, it could be an estate sale. It may be brand new construction, or it may be a foreclosure. So those are the three most common reasons that a property is exempt from providing that disclosure. And then the mineral and oil and gas rights disclosure, same thing there. The mineral and oil and gas rights disclosure, I call my Jed Clampett disclosure, which means if you're out in the backyard shooting at some game and up through the ground comes a bubbling crude, who owns it? So if the seller has not maintained mineral and oil and gas rights, then the current owner owns it. Okay. All right. Here we go talking about assessments again. This says that the buyer is responsible for proposed special assessments. They have their own closing costs that they are responsible for, anything with respect to getting their loan and inspections and all that. And it lists all the other things that the buyer is responsible for. Then it says that the buyer gives permission to disclose their information. So on a settlement statement, the seller can see a settlement statement with some of the buyer's information on there. Number 7 is how long the seller has owned the property, and you can usually get that from the tax record. And B talks about whether the property was built prior to 1978, at which point they may have used lead paint when they painted that house. And then there's a disclosure that you'd have to write up and have the seller fill out regarding lead paint. C again talks about assessments. I'm not going to go through that again. Owners Association and dues. So this says there is or is not a homeowners association, and these are the things that the buyer can get a copy of. So you would click that box, list the name of the association, how much the dues are. So if it's $100 a month, you could put $100 here per month, or you could put $1,200 per year. And then the name and address and telephone number of the president or the association manager. And that would go here. There's 2 places because some houses are located in a community where there are 2 associations. So let's pick Landfall, for example. There's a POA, which is the Master Homeowners Association, that covers the entranceways, the security, the pool, the clubhouses, blah, blah, blah. And then maybe the house is located in a small community where they also take care of yard maintenance. So only that small community would have an assessment or a fee that would have to be paid because of the yard maintenance. So that's why there's 2 of those. Then it goes into seller's obligations. Again, I'm not going to read all this to you. The important thing is they have to remove all their stuff by closing. Now, a trash can at the end of the road waiting for the garbage truck to come pick it up is considered cleaned up. Okay, it means I haven't left all my stuff in the house for somebody else to clean out. Affidavit and indemnification agreement, the seller will sign a document saying that any work that's been done in the last 120 days has been paid for, so it doesn't turn into a lien against the buyer and the property. This says they have good title and they can provide a general warranty deed, which is the highest form of ownership in the state of North Carolina. And then here is where we would write in the names of the buyers or however they want to take title to that property. So the deed is to be made to, and you would fill that out. And then if the buyer is asking the seller to pay any amount of money towards their closing expenses, you would enter that amount here. Prorations and adjustments, we're going to prorate taxes. and HOA dues. If we closed on June the 30th, the tax bill for this year hasn't come out yet. So the attorney would collect 6 months worth of taxes from the seller. And then when the bill came in September, then it would have to be paid by the buyer. But if they're escrowing that amount of money in their mortgage payments, the amount they collected from the seller for the first 6 months will technically go straight to the lender, to their escrow account, and then it would be credited towards that bill. Then it talks about home warranty. If there's going to be a warranty provided, who gets to pick what it is? If the seller's already paid for one, it would go here. Risk of loss. If the house burned down prior to closing, the buyer wouldn't have to buy it. That's a relief, right? Any delay in settlement or closing. So there's a built-in 14-day period in this document that you don't have to get anything signed or agreed upon if you close within 14 days of the original settlement date in this contract. And that can be given to a buyer or a seller. So if the seller is buying another home and all of a sudden there's a delay on their end, they can say, well, I'm not closing on my old home before I can close on my new home. And they've got 14 days built in to be able to do that.
Hey,
After
Jody.
that, then the person can terminate.
Jody, I have a quick question.
Sure.
So, new construction is sometimes fluid. How's that, right? So how's that work when you're trying to do a closing and,
Yeah. So if it's
beyond 14 days?
If it goes beyond 14 days, you have to have the new date, settlement date approved and in writing.
Okay. All right.
Okay.
So that's all. You don't have to
Yeah.
do a new
So
contract.
if it's within the 14-day period, you don't have to do anything.
Right.
If it's going to be, oh, we won't be able to close for another 21 days, then the buyer and the seller both have to agree to that.
Okay.
And there's a form for that. It's called the agreement to amend.
Okay.
Okay.
Thank you.
Then we talk about possession. So I used to say, please don't let anybody move in before closing or let a seller stay after closing. But what we're seeing in this market is sellers may not have anywhere to go until they close on their house. So getting a 2-month seller possession after closing agreement is becoming very popular. That gives them the opportunity to buy something else and not be worried about where they're going to go during that time period. Also, you might have a tenant in there and maybe the tenant doesn't move out till the end of May. So the buyer says, that's okay. They stay till the end of May. I know I can't move in until then. Then here are all these different addenda that we could have attached. And we're not going to go through all those today, but you would check the box for the appropriate ones. And then in this blue box, and this is very important, under North Carolina law, real estate brokers are not permitted to draft addenda to this contract. So if your buyer says, hey, could you write up an agreement that says, if the house doesn't appraise, I'll pay the difference in cash? No, you cannot. You cannot write any legal documents and attach them to this offer. If they want something written up, they can hire an attorney to do that. But you as a broker are not allowed. Again, they're hiring you to be their realtor, not their attorney.
Jody, does each office have like a list of like attorneys that they would recommend to use, or is that something I would maintain on a personal level?
It's usually maintained on a personal level, but any of us could help you with, our favorites that we use. And a lot of us use the same people. So I would say that's something you would want to make your list of, whether it be an attorney, an inspector, a lender, any of those things. And we can all share with you the people that we use, and you could come up with your list from there. Assignments. So this says a contract may not be assigned without the written consent of all parties. So that means if I'm the buyer and I say, oh, you know what? I don't really want to buy this now, but I'm going to let my brother buy it in my place. That's fine. It just has to be approved. It has to be agreed upon. Tax deferred exchange, that's a 1031 exchange. That just allows for a seller to get to a buyer and a seller to agree on that. Parties. So let's say the seller passes away while it's under contract. This says that the seller's heirs have to honor the contract that's in place. Now, it might take a little more time, but they are obligated under the terms of the agreement. Survival, if there's anything that should happen during the course of this contract and it gets overlooked or it doesn't get done in time, then the buyer can hold the seller accountable to the terms of this contract after closing. And this is our entire agreement. We don't have any deals going on under the table with the seller or with their agent or anything like that. Number 20 is conduct of transaction. This means that we can use electronic signatures as an approved method of agreeing to items. And then if we use number of days, like due diligence date would be 21 days from effective date. This would explain to you how to calculate those days. And then this is the signature page. And of course, at the top of the page, it says, if you don't understand anything you've read in this document, you need to consult a real estate attorney and they'll confuse you even more. Sorry. Here's the same wire fraud warning that we saw in the buyer agency agreement. And then this allows putting addresses in here for mailing addresses for the buyer and then seller. And then the selling firm information. If you're working with a buyer, this would be your information. And then this would be the listing agent information. Normally this gets auto-populated, but sometimes it leaves out a firm license number or individual license number or something like that. So just when you go back to the listing, you'll find all that information down here at the bottom. So the listing member would be Team Pinpoint Properties, the phone number, and then an email address. And then the last page is where this is like our receipt page. So when the buyer pays their due diligence fee, it would be signed by the listing agent accepting it and or the seller accepting it. So if you did an electronic transfer, like by Venmo directly to the seller, the listing agent wouldn't have ever touched it, so they wouldn't have a need to sign it. And then if you deposit the earnest money with a closing attorney, then here is when you take that money to them, this is where they would sign that they've accepted it. And that's it. Questions? That's a lot of stuff. And by the way, I forgot to tell you, you will not be an expert after this class.
Jody, way back in the beginning, we were going over the firm license number. Yes. And the office address. With those two right next to each other, they're asking for the Wilmington address because it's the firm address? Because I'll be under Anna Almond out of Oak Island. Is that the address?
That would be your address then.
That'll be my address. Okay.
Address. It's the same firm license number, but a different mailing address.
Got it.
Okay. Good question. Anybody else? So I'm sure in part of your orientation, they told you that the first 5 or 6 documents that you create for or transactions that you have, they need to be sent to me to review. And the reason is, and I need to review them before your client signs them and before you turn them in, because if you wait until you've already turned them in, then it's too late. And if you made a mistake, I can't help you because they've already obligated themselves. Okay. So I'm usually pretty, accessible. And I'm sensitive to know that the market today is very competitive and time is of the essence. So I really try to review them as quickly as I can. And I may, you'll send me, please review this offer for me, and I'll look through it. And I don't want you to be offended if I send you a quick note back that just says on page 2, do this, 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 on page 4, do this, 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 and page 7, do this, this, this. It's very straight and to the point. It may seem a little short, but that is not my intention at all. Okay, I'm usually pretty busy, and that's why I reviewed it. I've sent you back my feedback. It's not polished and, in no form, warm, fuzzy text, but there's no offense in the way that I send that. So please don't take any.
Hey, Jody, in counter offer situations, and they just want to change one thing, maybe it's the price. Do you want to review the full offer?
No, I don't. No, I don't need that. If you just change one thing, once I've gotten the full offer and I've reviewed everything you've written, if you make one little change, I don't need to see that.
Okay.
Okay.
Thank
Now,
you.
if you added an addendum, or if terms really significantly change, then at least for the first few, you would probably want me to take a look just to make sure it's been done right. And if you reach 5 and I've reviewed them and you want me to review number 6 through 10, I'm okay with that too. We just said at a minimum, the first 5 should come through me. All right.
So I'm marginal at best at getting the DocuSign documents where they're supposed to go now. So are we doing the DocuSign class with you?
No, that would be with Chris Cox.
And I'll remind Chris to show us how to send them to you first.
Yeah, and you can just save it as a PDF.
Okay.
Send me a PDF if that's
Okay.
easiest. Okay. Other questions? No?
Now, this was really useful. Thank you very much.
And I know it's a lot, and you guys are like fairly new, so it's probably a lot of information that you might not be prepared to receive at this point. So it doesn't offend me not one bit to go over this stuff again with you. If you have, once you have your first deal, then it's really going to mean something, right?
Yeah. So if you see me on the Zoom in 2 weeks, don't be surprised.
No, you can come as often as you want.
Okay.
I do these every other Monday usually, and
Okay.
I'll alternate between buyer forms and seller forms. So you could come as often as you want. And then I've also recorded it today. So Mia will have access to those and give you access to go to the recording as well.
Excellent.
All
Do you know
right.
when the Chris Cox DocuSign thing is?
Yeah. It's 1 second.